Okay, we are on the record March 22nd, 2022 at 9:38 a.m. I am Charo Dunlap, Texas CSR number 6733, located in Fort Worth, Texas. The witness, Donna Milburn, PhD, has been verified by state identification prior to going on the record and is located in West Tawakoni, Texas. Will counsel state appearances, agreements, and then I will swear in the witness.
Go ahead, Tom.
Tom McElroy for Mr. Crockett, petitioner in the case.
My name is Chris Hayes. I represent Nikki No, and I assume we'll just take them under the rules. Are you okay with that, Tom?
I'm good, Chris.
Thanks.
Ma'am, would you raise your right hand? Do you promise on your oath that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. You may proceed.
Thank you. Dr. Milburn, could you please state your full name for the court?
Donna R. Milburn.
And just a few housekeeping matters. First thing I want to talk to you about is saying yes or no and not and uh-huh. Are you familiar with that?
Yes, ma'am.
Okay, and if I catch myself doing it or if I catch you doing it, we'll try to work through it together, okay?
Appreciate that.
And sometimes, as you know, attorneys talk over each other. I'm going to try real hard to not ever talk over you, and I would just ask that you try and do the same for me when I am asking questions, okay?
Yes.
As far as objections, you may hear objections from time to time, but unless you're specifically instructed to not answer, you are to answer the question that you're being asked, okay? And
okay.
If for some reason you don't understand my question and you need me to clarify, please just ask me to do so and I'll try to take another stab at it and see if we can clear it up, okay? Is it a yes? Okay. Okay, and lastly, if you need a break at any time, just let me know. I'm happy to accommodate whatever breaks you may need. And now, can I have your agreement today that you are going to answer all questions truthfully to the best of your ability?
Yes.
Okay. Now, I am going to show you what I have marked as deposition exhibit number 5. Do you recognize this?
Yes.
What do you recognize this to be?
That is my curriculum vitae.
And did you submit this in the scope of your employment with the petitioner, Mr. Lauriston Crockett?
Yes.
Is this a current copy? And I'll scroll all the way down so you can see it. Is this a current copy of your CV?
Yes, it is.
Okay. Now, are you currently a licensed psychologist in the state of Texas?
Yes, ma'am.
And could you tell the court what is your license number?
It is, hold on a moment, I think it's 4936. I don't know that off the top of my head, but it should be at the bottom of an opinion report. May I check?
Sure.
The license is 2-4936.
And how long have you been licensed in the state of Texas?
Since, I believe, 1994.
Is your license currently in good standing in the state of Texas?
Yes, it is.
Has there ever been a time that you recall that your license has not been in good standing in the state of Texas?
Never. It has always been in good standing.
Are you licensed in any states other than the state of Texas?
No.
Have you ever had any complaints made against you, against your license in the state of Texas?
Yes.
How many complaints have been made against your license in the state of Texas?
I believe I've had 4.
And let's talk about the first one. When was the first complaint you had made against your license?
Oh, I don't recall.
Okay.
I've been practicing for a long time, for over 30 years. And the first 3 complaints would have probably been back before I changed my office policies and procedures. So we're probably looking at the late 1990s, early 2000s. And the last complaint would have been, the 4th complaint would have been, oh, I want to say maybe 5 years ago.
Let's talk about the last complaint 5 years ago. What was the basis of that complaint?
This was out of Judge Lopez's courtroom. The father was unhappy with the recommendations. It was a child custody evaluation. That's what all 4 complaints have been involving. And the father was unhappy with the not only the custody evaluation, but that was an unusual case that it was ongoing for 6 years. So the court had ordered me to do quarterly updates in that case for a total of about 6 years. And then he filed a complaint.
Because he disagreed with your recommendation.
He disagreed with my recommendation, and he disagreed with the court ordering me to do those follow-ups for continuing to do updated custody evaluations.
Did you receive any reprimand or disciplinary action as a result of that complaint?
No, ma'am.
Have you received any reprimand or disciplinary action as a result of any of the complaints?
Never.
Okay. Now, you indicated that those complaints came out of the conducting a child custody evaluation. Is that right?
That's correct.
And how many child custody evaluations have you conducted?
The current number should be close to 460, and I have 1 case still pending in a Dallas court. So that'll make it 461 by the end of the month.
And do you intend to continue doing child custody evaluations in the future?
That is such a hard one. I'm semi-retired, and so I thought I was going to be able to completely stop doing this kind of work about 4 years ago, and I've just had difficulty getting it to end, because when the judges appoint me to do these evaluations, I have a tendency to say, all right, this court really needs it done. There are not a lot of us who do them, so I've accepted them, but my hope is that this next one that I finish will be the last one. Knock on wood.
Okay. And you've indicated that you're semi-retired. Are you retired from all aspects of private practice, or just conducting or hoping to stop conducting child custody evaluations?
From all aspects of practice. I've got about 10 patients who have kept with me through the COVID process, and I just can't get them to transfer to other doctors because they've known me for so long. And I have a couple of cases in Hunt County where they just don't have the expertise out here to handle the type of diagnoses these individuals have. And so I've gone ahead and taken them on at a real low community service rate.
I see. Have you written or published any papers or articles on how to conduct a child custody evaluation?
Yes.
When was the last time that you published an article or a research paper on conducting a child custody evaluation? Do you recall?
I think the last article that was published, I didn't publish it, but it was several years ago. It was in the American College of Forensic Examiners publication, and it was on the need for mental health professionals to have more protection from board complaints and those kinds of things when they do these evaluations.
Okay. Can understand why that would be an interesting area for you to pursue. And as far as clinical positions, what clinical positions have you held?
Once I graduated from UT Southwestern Medical School, I finished up extra practicum experience and extra internships at the University of Texas at Arlington. And I did work for Psychological Resources of Dallas, which is a court-based practice, and for Psychological Services of Plano, and then ended up in my own practice following those.
And
So
when
I've been
did you,
private practice since then?
I'm sorry to speak over you. When did you go into private practice?
In, I believe it was 1994.
And when did you kind of start tapering off your patient list, for lack of a better word?
In, I would say 2017.
Okay. And what current professional associations or affiliations do you have?
I'm in the American Psychological Association and in the American College of Forensic Examiners. I don't know that they are operating under that name anymore. They moved to American Board of Psychological Specialties. And so I was a member of that. And to be honest with you, in the last year, I have not looked to see what those organizations are doing.
Okay. And again, that goes back to your hope that you can soon retire.
Yes.
Okay. And as far as we talked a little bit about clinical positions in your published papers, has there been any articles that you've published in the last 5 years regarding child custody evaluations?
No, ma'am.
Have you had any articles published in the last 5 years on any topic?
No.
Is it fair to say that 2017, you really started kind of tapering off a lot of this involvement, hoping to retire?
Yes.
Okay. Now, have you testified as an expert in the past?
Yes.
I understand it's difficult, but can you approximate for me how many times you've testified?
I would say with depositions, maybe close to 200.
You've given your deposition 200 times?
Or testified in trial.
Okay. And would you say that you're split equally on testifying on behalf of a mother versus father, or do you find that you are heavily weighted one way or the other in your testimony?
Almost all of my cases are court-appointed custody evaluations. So I'm testifying not on behalf of mother or father, but instead on behalf for the court on what's in the best interest of the child. I think that it's been pretty even in terms of how many cases I've ended up recommending kind of primary to the mother and primary to the father. It's been pretty even.
Okay. And when was the last time you were court appointed to conduct a child custody evaluation?
In December, I believe it was signed by Judge Turner in December of last year, 2021.
Okay, so that was my next question. Was that in Dallas County?
Yes.
And is that the one remaining case you've indicated you have open?
Yes, although I should clarify, I do have cases open for trial. I have, for example, a trial in August on a custody case out of one of the Dallas courts. So while I'd like to retire, these things last forever, it seems.
I'm sure COVID did not help that.
No, but it changed my travel schedule a lot.
Have you, when you've indicated that you've been appointed by the court to conduct a child custody evaluation, have you ever been appointed by the court to serve as a therapist for a party?
Yes.
When was the last time that occurred?
That had to have been at least 4 years ago.
Okay. And when you were appointed by the court as a therapist, was that for an adult or for a child?
For a child.
And was that for a child over the age of 13 or under the age of 13?
Under the age of 13.
How old was that child?
I believe she was 8 at the time.
Right. And what were the presenting problems with that child that the court ordered you to serve as a therapist role?
That child had a mother who lived in Dallas County and a father who lived and was stationed in the service in California. And the child refused to see the father and refused to have any kind of visitation or contact with him. And there was an allegation of sexual contact between an older stepbrother and that child when she was, I believe, around 6. The child also had an extreme, what we would call a psychosomatic reaction to the events involving what was going on in the family, had been hospitalized at Children's Medical Center, had had a partial paralysis that was psychologically induced from the stress. And so I was ordered to treat the child, liaison with the psychiatrist at Children's Medical Center, and try and get the child kind of back on her feet and functional.
How frequently since 1994 have you treated a child under the age of 13 in a therapist role?
I've always had children that I've treated. So my practice, my training involved working with children and families really as young as 1 year. I worked at Scottish Rite Hospital with families and very young children, and working in school districts and doing testing for school districts. So I've had children in my practice, private practice, typically starting at age 2, all the way up through, I've had geriatric patients. So it's been a pretty well-rounded practice over the years.
Have you ever have you ever treated a child in therapy in your private practice that presented with issues related to alienation?
Yes.
And can you recall the last patient you treated that presented with issues that you deem associated with alienation?
Well, I'm going to suspect the best guess I can give is going to be I haven't seen someone being treated for alienation since 2017. Because
Okay.
like I said, in 2017, I really was trying to decrease my patient load and move toward this retirement.
Have you ever been either court appointed or conducted a psychological evaluation of a child in the state of Texas?
Yes.
Approximately how many times?
Oh, again, that's a tough one over a 30-year practice. Part of my work initially and my training was at the Dallas Juvenile Detention Center. So I spent 1.5 years. By the last year, I was appointed to do evaluations twice a week on children in the juvenile system. And then the Dallas court has appointed me to do evaluations, and the Collin County Court, Denton County, Tarrant County. I get appointed to do those evaluations more than probably most people.
Okay, and when was the last time you conducted a psychological evaluation of a child? Was it back in 2017 approximately?
It would be approximately back then.
And have you also assisted in clinical interviews of children throughout your 30-year history?
Yes.
Fair to say again that 2017 was probably the last time that you conducted a clinical interview of a child?
No.
When was the last time you conducted a clinical interview of a child?
I would say probably last September, October.
Was that related to conducting a child custody evaluation ordered by the court?
Yes. And I'm sorry, I need to change that a little bit. I also have conducted a clinical interview of a child in February related to the problems they were having.
In that February of 2022?
Yes.
Now, in this case, you were hired by Mr. Crockett, is that right?
That's correct.
And what was the scope of what you were requested to do for Mr. Crockett?
I was hired by Mr. Crockett through his attorney to review Jennifer Frendel's social study report and to review materials in the case and to provide an expert opinion regarding the social study she conducted and to look and see if there were going to be allegations regarding parental alienation or other child-related issues and to testify as a possible rebuttal expert on those issues.
And have you been retained to provide that expert testimony in this case?
Yes, I have.
Did you know Mr. Crockett prior to being hired in this role?
No, I did not.
And had you worked with his counsel prior to being hired in this role?
Yes, I had.
Which of his attorneys had you worked with previously?
Mary McKnight.
When you are hired in the capacity to review a child custody evaluation for compliance purposes, what is the first thing that you do once you've been retained?
The first thing I do once I've been retained is I make sure that both the attorney and his or her client, in this case it would have been Ms. McKnight, and the father, Lauriston Crockett, understand what my role is, what I'm willing to have my role be. So I don't do a lot of expert testimony where one side or the other side hires me. I've only done that maybe 6 times in my work because that's just not what I like to do. I much prefer the court-appointed child custody evaluator role or treatment provider role. So first I make sure that they understand the limits of what I'm willing to do, that I'll review material based on what it is they've asked me to do, and that they also understand that while I'll give an expert opinion, so you'll get it in writing, it's not going to be something that, you know, I'm not one of those doctors who goes on the stand and pontificates on the stand. People will know what my opinions are. Everyone will see them in writing. And I will not step outside of my role. For example, I make it very clear in my write-up, I am not meeting with this child. I do not know the mother. I'm not meeting with this mother. I will not be offering any opinions regarding possessions or access of this specific child because that's outside the scope of what I'm being hired to do and outside the scope ethically of what we're allowed to do. So I make sure that my role is very clear. Then I meet with the parent in person and I get a history, and I also have them fill out all of my office policies and procedures so that they also are aware in writing of how my office works, what the fees are, that kind of thing.
Have you been paid in this case as an expert?
Yes, ma'am.
And how much have you been paid to date by Mr. Crockett for your expert opinion?
To date, I have been paid, a total of $5,825.
And does that amount include the time spent to review the child custody evaluation and generate a report?
That includes all of my work on this case up to this deposition. And he currently has a $500 credit that will go toward this deposition, and he's charged by the hour for my time,
What is your hourly rate?
$225.
Is that the rate you normally charge on cases?
Yes.
You indicated, and correct me if I'm wrong, did I hear you say this is probably the 6th time that you've testified as a rebuttal witness for a child custody evaluation?
That's correct.
Were you given any unique information about this case that enticed you to accept the scope of work being requested from you?
Well, I don't know about unique, but I think that one of the reasons that I took this case is because Ms. McKnight called me and said that she really needed some help. She needed another expert to look at Jennifer Friendle's report. I think my impression was that she was very surprised at the report, and there were some significant missing elements to it, and she wanted someone such as myself who've been doing these for 30 years to look at this and give an opinion on it.
Did she tell you when she contacted you that she believed there were numerous missing elements?
Yes.
Did she discuss the facts of the case as she perceived them with you at the time she contacted you?
She discussed,
Excuse me.
God bless you.
Thank you.
I don't know that she discussed the facts of the case, but I do know that she discussed what she felt like Ms. Friendle had not done.
And what did she,
missed.
I'm sorry, what did she tell you Ms. Friendle had not done or missed?
A good example is that Ms. Friendle didn't see the child in the homes of the parents. So she went and did a home visit during the time the child was at school and never actually got to see the child in the home environments. And that she told me that Ms. Friendle had met with the parents a pretty limited amount of time and had not ever seen the mother individually. So even though, and I found when I looked at the report, even though Ms. Friendle said that it was an individual interview with the mother, the boyfriend at the time, who then later became the stepfather, was physically present in the room. And when she did the child observation with the mother, the stepfather was also present in the room, which is not what the Texas Family Code requires. It's a problem.
And are these things, I understand you're telling me things from your report, but are these things that Ms. McKnight is telling you?
Ms. McKnight told me that those had happened and she was concerned about those.
Okay. And was it her that said these things are a problem and not in compliance with the Texas Family Code? Or is that a statement you're making to the court today?
That's a statement I'm making to the court today.
Okay. At the time that Ms. McKnight contacted you for purposes of reviewing this child custody evaluation, did she indicate whether she was in agreement with the outcome or the recommendations of Ms. Friendle?
Trying to remember if she specifically said, but I would assume she was not happy with the recommendations made by Ms. Friendle.
Okay. And in that conversation, the two things you specifically remember was the fact that there was no visiting of the child in the home environment and the stepfather being present during the interview. Are those the two things you recall her telling you?
Yeah, I recall her mentioning those.
Anything else that you can recall her mentioning on that phone call regarding problems that she had with the child custody evaluation?
No, not that I recall.
Okay. And how long after that phone call with Ms. McKnight did you move forward with review of the child custody evaluation?
May I look at my file?
Sure, of course.
Okay, so because I can give you dates on that. All right, are you ready?
Yes, ma'am.
Okay, so I was hired on December 10th, 2019. And there was a charge for a half hour of work on that for taking the call and being sent the information. And then I reviewed material in December, 12/11/2019, 12/12/2019. I met with the father and conducted his interview on 12/12/2019. He provided a retainer at that time. 12/19/2019, I received more materials and reviewed it. And then the information review continued through December of that year, with report writing beginning 12/28 and continuing through to January. And I believe the first expert opinion was issued January 7th, 2020.
When you are reviewing a child custody evaluation for rebuttal purposes, do you only ask to be given the same materials that were given to the original evaluator?
No, ma'am, not at all.
Why not?
And so if you clarify, when I'm doing what I was hired in this case to do as a rebuttal expert was to look at what Ms. Frendel did and to provide an opinion regarding kind of the process of what she did. I am not redoing her evaluation. So it's a little bit of a different thing. I don't ask for them to provide me with everything that she looked at. They provide me with the information that they provide. I look at her report and what all she looked at. I look at the things in this particular case that the father claimed that she refused to look at. He provided those to me and I looked at those. And so this is really a rebuttal in that respect. I don't redo somebody else's child custody evaluation.
When you're reviewing somebody else's child custody evaluation, are you not looking to determine whether that evaluator followed evidence-based practice methods to ensure they were utilized properly when making recommendations to the court?
Yes, I do.
And how could you review to ensure compliance with 107 if you're not reviewing the evidence that the original evaluator reviewed?
Okay, so let me give you an example.
Okay.
When the original evaluator does an evaluation and does not conduct an individual observation between the parent and the child, that I don't need to have her records of her notes of that. Her report stands for itself when she says that the stepfather is present in the room. And that raises a concern. When the report that's issued says that the evaluator didn't talk to one of the parents' therapists, didn't receive records from one of the parents' therapists, didn't talk to one of the parents' psychiatrists, didn't receive medical records for one of the parents' psychiatrists, didn't review school records. If those things are missing in a report, then that raises concern about the content of the report, if the evaluator actually looked at everything that they need to look at. If in an evaluator's report, there's a bias in terms of the wording in the report, if the evaluator has written, like I believe happened in this case, several pages against one parent and concerns against one parent, and then minimized concerns or ignored similar concerns against the other parent, what they've written in the report is of concern. So I guess I just want to make it clear, I don't ask for the attorneys to give me, for example, mother's specific information, whatever mother has provided, because I'm not looking at what mother says versus what dad says to offer a different opinion regarding the custody evaluation itself. I'm looking at what the expert did. And if the expert did everything that they're really supposed to do under the Texas Family Code, so they can make the recommendations that are in the best interest of the children. And in this case, there's the additional concern that there's parental alienation going on. Ms. Frendel was concerned that there was parental alienation by the father going on against the mother. And she talked about that in there regarding the CPS complaint about the bite on the back and about the uncle being in the bathtub with the child. But his concern is that there was parental alienation going on by the mother, destroying his relationship with the child. And so he, through his attorney, offered and presented information for me to look at regarding assessing whether or not that could be going on.
I'm sorry, what was the last part? Whether that could be?
Whether that could be going on, whether they're concerned that the mother was engaged in parental alienation of the child towards the father.
You would agree with me that when conducting a child custody evaluation, the evaluator has very broad discretion so long that they comply with the Texas Family Code, right?
I have a different opinion on that. I would disagree with that.
Okay, tell me why you disagree.
The legislators and legal professionals and mental health professionals have, in my opinion, worked very hard over the last decade to really get the Texas Family Code and our professional board rules for all the licensed mental health professionals kind of in alignment and much more strict about what we're allowed to do and what we're not allowed to do. And those very strict rules provide a guideline that doesn't really allow us to maneuver outside of that very much. If we don't do, when I'm doing a child custody evaluation as an expert, when I or other experts don't do what the Family Code tells us to do, then we are required by law to put in our report exactly why we deviated from what we were supposed to do. And we are also supposed to put in there an opinion as an expert about whether or not that would have a ramification on the recommendations we're making. So for example, the Texas Family Code says that you must do an observation of a child with a parent. That's it, it's in there. You're supposed to conduct that evaluation, and your evaluation interviews are supposed to be consistent between both parents. So if you do an evaluation with a parent and a father and you see them together, and then you do an evaluation and you see a parent and a mother, but you don't see them alone, you have the stepfather present, you fundamentally have a different type of evaluation going on there. Now, an evaluator can do that.
Let me stop you right there. Tell me why you think that is significant. Why is it significant to you that the stepfather was present in one interview, but yet father, who doesn't have a significant other, was alone in his interview? Why is that significant?
Because in this case, the complaints and concerns that brought it to the court in the first place was that the mother had bit the child on the back and had left bite marks on the back, and that the mother were, that the uncle had been in the bathtub with the child, and that there were concerns about the mother and the child's relationship and how they interacted. So for Ms. Frendel to look and see whether or not the mother and the child had a healthy interaction, and to ascertain whether or not the child at that time might have been nervous about the mother, might have been fearful of her, might have been coached by her, all the kind of things you would be looking for going on between the mother and that child, you're not able to assess as a mental health professional when you have another adult in the room. The child might appear very happy and very comfortable playing games because stepdad's there and loves him and is happy with him, but might have looked very different if it was just mom. And so I'm not saying how the child was or is, but what I am saying is Ms. Frendel, I believe, had a duty to conduct both the evaluation the same for both parents. And if she decided not to, she decided she was going to deviate from the Texas Family Code, then she had a duty to write that in her report and explain what the possible limitations in her report and recommendations were based on the fact that she decided to do something different with each household.
Can you cite to the court the exact section of the Texas Family Code that states it is improper for the stepfather to be present during the interview?
There is no section that says it is improper for someone to be present. However, in those exact terms. However, in the Texas Family Code, it says that individual interviews will be conducted with each party to the suit. Ms. Frendel, in her first evaluation, I understand she's doing an update, but in the original social study, did not conduct an individual interview with the mother. There was no individual interview with the mother in her report.
And you are citing to section 107, 109?
Yes,
okay.
on section 107, 109, subsection C, the basic elements of a child custody evaluation under this subchapter consist of 1, a personal interview of each party to the suit.
And you would agree with me that nowhere in that subsection does it indicate that needs to be solely that individual, right? It just states a personal interview, right?
I would tell you after doing this all these years, it's supposed to be an individual interview.
Objection, non-responsive. You would agree with me that it says a personal interview and it makes no mention of whether anyone else can be present, right?
I agree with you that that's what the wording is here.
And what you're telling this court is that you just don't believe that's the best practice. Is that right?
No, I'm actually saying more than just don't believe it's the best practice. The child custody evaluations that the Dallas court and the Collin County courts have been ordering for me in the last 4 years have actually involved a very clear stipulation in the language even, where they say an individual interview of the father, individual interview of the mother, individual interview of the child without the parent present. So they're listing all of those details now in the court orders that I receive, making it very clear when they come to my office to conduct my evaluation the same way I always have, which is consistent with this code.
And when did the Collin County courts begin stating those things specifically in your orders?
I think it's been since, trying to see if I think 2015 is when it started being very specifically written. I think that if I remember the date correctly, 2016 is when the new laws for the Texas Family Code went into effect. But by 2015, they were actually writing those in my orders.
See, and have you had an opportunity to review the court ordered for the child custody evaluation in this case as it pertains to the subject child?
I don't think so. Not that I recall.
Now, you've indicated in your report that you believe the presence of the stepfather made those interviews unbalanced. Can you explain that word usage to me, unbalanced?
Yes. So when an expert is evaluating the parents or the parties of a case, one of the things we're doing is we're looking to assess what information we get from one parent compared to the information we get for the other parent. And in this case, we're going to assume parents. Sometimes it's grandparents, sometimes it's other foster parents. But in this case, because we have a mom and dad, I'm going to talk about it in terms of mom and dad. So when you're making a comparison between what dad tells you is going on in the home and with the child, what mom tells you is going on in the home and with the child, what dad tells you is the history of the relationship with the other parent, what mom tells you is the history of the relationship with the other parent. Very often, as the expert, we're trying to figure out between this person and this person's version, where is the most credibility and where are we likely looking at the most relevant information relating to the child and the best interests of the child. When you have another person in the room, boyfriend at the time, later now a parent, a step parent, what you have is a situation where you've got the influence of another adult in the room. So that other adult may be coaching, using signals, doing involuntary movements. There's a change potentially in what mom is sharing with the evaluator because she's got a co-person there who's assisting her with that.
And just to be clear for the court, you're not indicating that that occurred in this case, just merely that you would have done it differently, right?
Correct.
Okay. And had the boyfriend at the time been a stepfather, would your opinion be any different?
No, it would not.
Do you believe it's important to see the child with every member of the household when conducting these interviews?
Yes.
How would you have done it differently in this case?
Well, in this case, I would have conducted balanced interviews. I would have had the interview with the father individually and the interview with the mother individually. I would have conducted a separate interview with the stepfather individually. I would have had multiple interviews with these individuals. I typically see people about 6 hours, at least 3 different appointments. In addition to that, I would have conducted a home visit in each home where the child was present. So I would have gone to the mother's home where the mother, stepfather, and child were present. I have the child give me a tour of the room, and I get an opportunity to see exactly what that home environment is like. And I get to see the child in that home environment and with all members of the family. So in this case, it would have been with mom and stepdad. I would have gone to the father's home and I would have watched the child with that father. When a child is under a supervision order, what I typically do is I have the attorneys agree, and sometimes they run it through the court with agreement from the judge, that I essentially act as the role of the supervisor. So I don't allow the child or the father to be together without my presence, but I get an opportunity to see the child in the home, have the child give me a tour of the home, and then I get to watch the child and the parent interact. And I would have watched the child and the father interact in the home.
And so in that testimony, you've jumped from not just seeing the child alone, excuse me, not just the interview process, but also seeing the child in the home environment, right?
That's correct.
Okay. And I'm going back to just the issue with the stepfather. Would you ever have conducted an interview with the child with just the mother and then the mother and the stepfather not in a home environment?
I will do that in my office when I'm working in Plano. I will do that, but I always will have an individual interview or an individual interview with each parent, with each step parent, with each child. And then if I conduct an interview where the child and the parent is present, and I do it in office rather than in the home visit, then I often will have the step parent as a part of that at some point. There would be, in this situation, where you balance it between the two, so that I have the same number of hours with each party who are parties to the case. And if I do have an additional step parent or step family that I have to do, then I balance it and I do the same amount of time in the other home.
And the model standards for child custody evaluations request or recommend that evaluators endeavor to employ procedures that will create a sense of balance, right?
Yes.
Would you agree with me that if you held 2 interviews for the child with their parent and then their parent and step-parent, and on the other side, only an interview with the child and that parent, that would no longer be balanced?
Correct.
So had Ms. Frendel given the child 2 interviews, one with the mother alone and one with the mother and stepfather, and yet only 1 interview with the child with the father, that would also be unbalanced, correct?
It would be unbalanced, and that's why she should conduct an additional one with the father and the child to balance it.
So you would recommend that she have 2 interviews with the father and the child to make up for the 2 interviews on the other side?
To balance it, yes.
Okay. Now, jumping to the child in the home environment, is it your testimony that Ms. Frendel did not see the child with either parent in his home environment?
That is what her report said.
And did you conduct any child custody evaluations during COVID?
Yes.
And did you conduct home evaluations during COVID?
Yes, I did.
Are you aware that Dallas County did not?
I'm not aware of what Dallas County Court Family Services did during COVID. I am aware that her report came out before COVID was a problem.
Objection, non-responsive.
You can finish answering, Dr. Milburn.
I believe that COVID had not come into play until early 2020, and Ms. Frendel's evaluation was completed in August of 2019.
Objection, non-responsive. My question is, were you aware that Dallas Family Court Services did not conduct home evaluations during COVID?
I'm not aware of what Dallas Family Court Services did or did not do during COVID.
Is it your opinion that if Dallas County Family Court Services did not conduct home evaluations during COVID, that the evaluations that were conducted are not in compliance with the Texas Family Code?
I believe what you're asking me for is a legal opinion. And so as a mental health professional, I don't really think I can answer that. The emergency order under Governor Abbott had very strict recommendations, and I believe Dallas County Judge Clay Jenkins was the one who issued how everything would be conducted. But since I am not an attorney and I'm not aware of that, I think that's a legal conclusion that I can't make.
Well, I'm asking you specifically whether or not you believe it would comply with Section 107 of the Texas Family Code. Do you agree with me that a evaluation of the home environment of the child is essential to be in compliance with Section 107?
Well, if you're asking for a personal opinion, I personally believe that a home visit is very important to do in any kind of custody evaluation. And I am not aware in Dallas County, but I'm aware in Denton County, in a few cases up there, that those evaluation reports actually ended up being delayed because the court-appointed experts in Denton County waited until they could conduct the actual physical home visits rather than just exclude them and not conduct them. I'm also aware that some of my colleagues who were working in Collin County did some virtual home visits for adoption studies. So they did those with, I guess, phone, Zoom, moving a computer around, or on the phone, Zoom, moving a phone around the home. But that's as close to an answer as I can give you.
Objection, non-responsive. So, Dr. Milburn, let's try it a different way.
Okay.
Can you tell me where in section 107 of the Texas Family Code it requires that an evaluator conduct an evaluation of the home of both parents?
Okay. So again, let me go back to my notes.
Sure.
Well, I didn't write anything about the home visit in my report, so I'd have to pull up the Texas Family Code, and I apologize, I don't have it in front of me.
That's okay. Let me pull it up for you. Okay, I am showing you what I have marked as deposition exhibit number 4. And can you see that? Let me see if I can make it bigger. Section 107, 109, elements of a child custody evaluation. Can you see that on my screen?
Yes, I can see it.
Okay. And if I scroll down, oh, I may have scrolled too far. Let's see. To subsection D, right here. The court may order additional elements of a child custody evaluation under the subchapter, including the following. Do you see that?
Yes.
And you're referring to this section right here, number 3, evaluation of the residence of each party seeking conservatorship of a child who is subject to or possession of this suit. Is that right?
Yes.
Is that the section that you were referring to when you were suggesting that the child should be seen in the home environment?
Yes.
Does it specifically state in this section that the child should be present at the time the evaluation of the residence occurs?
No, it does not.
And you would also agree with me that this subsection D is may order additional elements of a child custody evaluation under the subchapter, right?
Yes.
And you're not aware, as you indicated earlier, whether or not the court order in this case ordered that, are you?
No, I am not.
Okay. Just to be clear, are you aware of whether or not Ms. Frindle visited the home of either parent during the course of her evaluation?
Yes, I am.
And how are you aware?
In her report, I believe she has that listed.
Okay.
She went to the mother's apartment and she went to the father's home.
But it's your opinion that the best practice would have been to see the child in the environment of each home. Is that correct?
That's correct.
Okay. Now, I'm going to show you what I have marked as deposition exhibit number 2. Do you recognize this? It may take a minute to pop up.
Yes.
Okay. And do you recognize this to be the expert opinion report you've written in this case?
Yes.
And do you recognize that that's approximately 22 pages?
Yes.
Okay. And the report is dated January 7th. I believe earlier in your testimony, you indicated that was the date you issued your opinion. Is that right?
That's correct.
Okay. And if we kind of turn to the end here, and forgive me, I'm going to cheat and go straight to the end. You stated on page 17 of your report that you see bias, confirmation bias. Do you see that?
Yes.
Can you, in your first subsection, does Ms. Frindle failed to investigate or confirm the past and current history of the mother? Can you explain to the court why you think this information 1 through 4 is relevant? Well, strike that, shows bias to the mother.
when you read Ms. Frendel's report and what she put together, she has a lot of extensive information against the father, and she has limited her report regarding the mother in such a way that these are questions that arose for me when I read it, wondering why these weren't looked at. Could these possibly be an issue? She talks about the mother. Anyway, so those are the list. That's the list of things that were concerning to me in comparison to what she reported on the father.
And just to be clear, you're asking, when did the mother move to the United States from Vietnam?
Well,
Right.
there's a question that arose for me about this. So we've got a mother who has a different culture. And so there is a question about how long was she here in the United States? And the reason this is so important in this particular case is we have a situation where what kind of triggered all of this to start was the child returned to the father's home with some bites on him that he says the mother did. CPS report says mother confirmed to the CPS investigator that yes, she bites him sometimes in play. So the question that raised for me that Ms. Frendel didn't address or mention in her report was this mom, when did she move here from Vietnam? When you've got a different cultural influence, you're supposed to ethically understand that maybe the parent is doing behaviors that might be different than what you see in a normal American-born. And so I wondered, is this maybe something that culturally mom's family does, that it really is in play? I did do some research on Vietnamese background to see if I saw that in any kind of parenting practice. I didn't, but it is something as an evaluator you want to wonder or question about. You've got the allegation of the uncle being in the bathtub with the child and was definitely in the bathroom doing the bath, according to the CPS reports. So the question on that becomes, the child was 4 or 5 years old. Again, is this something kind of cultural or not? I couldn't get a clear history of this mother from the report, the way that Ms. Frendel did it. But Ms. Frendel did go ahead and say that the father was racist and claimed that the father had racism in terms of how he viewed the mother and the mother's ability to parent. Well, she calls him out as being a racist in her opinion and doesn't address this question or this topic about the Vietnamese background, how long she was here, and if in fact mother's language, English, is a second language or not.
And explain to the court how that in any way affects the recommendations made by Ms. Frendel.
Well, it doesn't affect the recommendation of what she thinks is in the best interest of the child, but it affects the recognition of the overall report and how it was conducted. I don't know if Ms. Frendel considered the ethnic background of this mother or not. She may have, she may not. It's not in her report. And in some ways, I wondered did she interview the mother with the boyfriend present, now stepfather, because the mother was having some trouble with English? I don't know why Ms. Frendel did what she did. And so when I'm doing an expert opinion on something like this, those are concerns for me.
But the word you used, Dr. Milburn, was bias. You've indicated that you believe Ms. Frendel was biased, a parent biased. And what I'm trying to understand is, why does mom's ethnic background or the fact that Ms. Frendel has either did consider it or didn't consider it lead to a bias finding?
Because when Ms. Frendel writes a report where she is calling the father a racist regarding how she perceives his views of the mother being from Vietnam or having a Vietnamese background, and she's using race as a part of her concern about the father and recommending sole custody to the mother and recommending that the father be under perpetual supervision whenever he sees the child. The issue of race has to be looked at. The issue of ethnicity has to be looked at. And to only be one-sided going after the father for this and using that in some of your conclusions, and to not look at anything on the other side is a bias.
Well, not to be obtuse, but wouldn't the fact that the mother is Vietnamese be apparent at the time that she met the mother?
Well, I don't know. I don't know how the mother appears. She may appear Chinese. She may appear Cambodian. I don't know.
But that's exactly my point, Dr. Milburn. You've stated that Ms. Frendel showed a bias when perhaps you just aren't aware of the facts, correct?
I think the bias that I'm referring to is not related to a bias related to the ethnicity. It's a bias and related to how Ms. Frendel evaluated the two parents and being very harsh against the father related to ethnicity and racial issues.
Were you aware? I'm sorry to interrupt you. Go ahead.
And not providing or looking at the other side and providing the information related to the other side. So I couldn't tell reading her report what the actual background was for mother. And that's a concern.
Did you become aware during a review of the child custody evaluation that it was the child who made statements about father's racial comments?
I don't recall that.
Okay, that's okay. You indicated whether or not the mother was a stripper in her past was somehow relevant to the child custody evaluation. Is that right?
That it was something that should be looked at, yes.
So it's your opinion that if a mother was in a dancer 10 years prior to ever having children, that that's somehow relevant to the best interest of the child today? Is that your testimony?
My testimony is that when a court evaluator is conducting an evaluation, they need to look at all aspects of both parents, meaning they need to look at what jobs the parents have held, look at the educational backgrounds of the parents, look at the income levels of the parents, look at everything related to the parents. The issue and the concern about this situation that Ms. Frendel did in her study is not whether or not the mother worked in the sex industry. It's that Ms. Frendel didn't appear to address or look at the possibility that the mother may have worked in the sex industry. And based on the information that I have, I can't tell you if she did or not. I don't know. So if she's working in the sex industry now, let's say right now with this child, again, I don't know. And I don't know if it would have an impact on her ability to parent or not. There are plenty of parents who are strippers, they're exotic dancers, and they're very good parents. And they have child custody of their children. They have child custody evaluations that come out that say, this is the best place for the child to be. So the problem is not about what the mother may or may not be doing or have done. The concern for me when I'm evaluating Ms. Frendel's report is, did Ms. Frendel look at this? Did she consider these things as an expert? If she considered them as an expert and she said, I'm not worried about that, this is still a great mom, she really has the best relationship and this is the best for the child, okay. But when I looked at her report, I didn't get the impression that she considered or she looked into those things.
When you say those things, these are things that the father told you about, right?
These are the things that the father told me about. That is correct.
Why would you meet with the father on December the 12th of 2019 and have a meeting with him prior to reviewing the child custody evaluation in this case?
I needed to conduct an interview with him to get his background and the background on the family, the child, and, you know, essentially it's his version of what's occurred.
And you would agree with me that that gives you an unbalanced perspective in reviewing the child custody evaluation if you've only heard one side of the facts from the parties, right?
It gives me an unbalanced perspective if I'm conducting an actual child custody evaluation or I'm offering a different opinion about what should happen with this child, which I'm not. I haven't seen the child. But when I look at a forensic expert's evaluation, and I come in and I provide this expert opinion, there's an automatic bias in that expert opinion.
Sure, but wouldn't it have been more objective for you as an expert witness in this case to not have met with the parties and to strictly review the report itself and make your determination and base your opinions on that?
There have been, like, as I've said, I've done this about 6 times. And one of the times I have not, well, I'll take that back. 3 times it was for the Texas board. So I didn't evaluate anyone. I just looked at the full evaluation and all the materials. And I was a witness for the board against the expert who had been unethical in their evaluation process. In 2 other cases, I think that's about right. I do it so rarely, I actually do have a pretty good memory of them. In 2 other cases, I didn't meet with anyone. Or one other case, I didn't meet with anyone, and that was out of Collin County with another attorney. But in this case, I felt like 2 things needed to happen. I needed to meet with the father, and as a clinical psychologist, make sure that I'm dealing with somebody who's being kind of upfront. He also, for my standards, needed to sign my office policies and procedures and understand what my role was going to be. And this is also a case where he was saying there's all this other stuff that Ms. Frendel didn't look at and wanted to provide that to me, which is his right to do if he's going to hire me to look at this case.
Objection, non-responsive. My question, Dr. Milburn, is wouldn't it have been a better practice to review the child custody evaluation alone and give your expert opinion about whether it's in compliance with the Texas Family Code rather than meet with Mr. Crockett and get his version of why he believes it's insufficient?
I don't believe so in this case, no.
Okay. So in the 6 times that you've taken this course of action, only 1 other time have you met with the party prior to review of the report?
That's correct.
And in the other case that you met with the party prior to, did you receive information from that parent about what they perceive the problems to be with the child custody evaluation also?
In that case, I received it through their attorney, yes.
Did you request to meet with Mr. Crockett personally rather than his counsel?
Yes.
Why did you do that?
I wanted to get an assessment of the person I would be working with.
And you would agree with me that an evaluator uses their intuition and makes certain determinations when they meet with the parties as well when conducting a child custody evaluation, correct?
That's correct.
And in this instance, you've only had the benefit of doing that with Mr. Crockett, not Ms. No, isn't that correct?
Yes.
So when you're giving your opinions in this case, you must concede the fact that your views are slanted in his favor because you're the only one he knows in the case, right?
Absolutely, absolutely. And that's why the judge weighs an expert opinion based on that. So in my experience, the judges, the courts are very good about being able to discern what a role of an expert is. And that's also why it's very clear at the beginning of my report what my role is. So the judge is aware and gives the proper weight to any opinion that I give.
I'll object to non-responsive after, absolutely. In reviewing your report, you indicated that Ms. Frendel failed to receive information from various mental health professionals. Is that correct?
Yes.
And you reviewed in her report that she had requested that information, but that it had not been received, correct?
Yes.
And she listed that in her report in compliance with the Texas Family Code, correct?
Yes.
And she also listed the limitations and how that may or may not be able to affect her conclusions in the case had she received them, correct?
I don't recall her paragraph on that.
Okay. And you would agree with me, and I don't mean to, I call it the catch-all child custody evaluation, where evaluators basically say, had I received this information, it may warrant a change in my recommendation, something along those lines. Do you use something like that in your practice as well?
I do. Typically in my reports, if I don't get, here's a really good example. I'll use that when, for example, I've asked for medical professionals to give me the parents' medical history, their general practitioner, since we're now supposed to be looking at all their medical history. And I will go ahead and finish a report if a general practitioner, doesn't send that evaluation, those medical records, as long as I'm not being asked to assess whether or not somebody is, for example, misusing prescription drugs like Xanax, or, has some kind of major mental health problem. And I'll put in the report that catch-all kind of phrase. If it changes something, then I'll come back and I'll let the court and the attorneys know if I get these records and something's in it that change it. What I do not do is issue a child custody evaluation where I have not gotten the records or gotten some kind of information from the mental health practitioners who are working with the parents or the child. I have to have those, because when we're talking about the best interests of a child, I need to know, in my opinion, how those parents are actually functioning. And if there's anything in those mental health records, I need to see it. So I typically will not issue a report without having received those records first.
And what happens in that instance where the mental health professional is requested numerous times to provide those records and fails to do so?
You mean in my office?
Correct. How would you handle that?
Well, I typically send them a letter that starts a little bit like Christy Bradshaw Schmidt's initial letters to all of us, where her initial letter says, you have 14 days to get this to me, or it's a board complaint because you violated your board rules. I'll give them about a month, and then I craft an email that looks a lot like Ms. Schmidt's initial letter, and I send that to them. And generally that results in me getting a copy of those records. And if I have a case like this one, where I'm concerned, if I was Ms. Frendel and I'm concerned about allegations of agoraphobia, narcissistic personality disorder, and and anxiety disorder, and those kinds of mental health issues, I believe she should have waited to get those records from father's treatment provider before issuing a report.
And I'm going to show you what I have marked as Exhibit 1, which is the child custody evaluation. And this is the section we're referring to, is the items that she utilized, received, and didn't receive in her child custody evaluation. And the section right here, I'm trying to make it bigger. Let me see. The following information has been requested but has not been received: employment verification, dental information for the son, mental health information from Dr. Chandler for Lauriston the 3rd and Lauriston the 4th. Is this the portion that you're referring to right here?
Yes.
And did you know Dr. Chandler was a treating physician for Mr. Crockett prior to that?
My understanding is he was a treating physician for both Mr. Crockett and for the child.
Were you aware that he was removed by the court for improper treatment?
No, I'm not aware of anything the court has done regarding him.
And had you become aware that the court ordered that he not be able to see the child, would you still find those information necessary?
Yes.
And why is that?
Because he was also treating the father. So those records might contain important information regarding the father's functioning.
And just to be clear, you were told by the father that Dr. Chandler was his mental health provider?
Well, I'm trying to recall, I believe the father's mental health provider, he saw Dr. Chandler and he saw Dr. Art Arazo. So I'd have to go back deep in my notes to see if the father specifically said Dr. Chandler, but I believe he told me that he was treated by Dr. Chandler, that he and the son were treated by Dr. Chandler, and that he was treated by Dr. Arazo.
Did he tell you who Dr. Chandler was?
I don't recall.
Okay. And you indicated here the mental health information from Dr. Rochelle Ritzie for the subject child, the father, and the mother.
Yes.
And this is the section you indicated that you would not complete your report had you not received that, right?
If I had not received the written records, the therapy records, that is correct. I would not have completed my report.
Do you know whether or not Rochelle Ritzie was the health provider at that time?
I believe she was.
And is that something that was represented to you by the father?
I believe I may have reviewed Dr. Ritzie's deposition. My understanding, and forgive me that I can't specifically say if the father, I know the father told me that. I know he did. I know it's in deposition form. I understand, if I recall correctly, there were various hearings regarding requesting the court remove Dr. Ritzie. The court, my understanding, from the best of my recollection, did not remove Dr. Ritzie. And she continued to provide treatment to the child. Dr. Ritzie had a lot of contact with mother on emails and with father. And because of Dr. Ritzie's role in this case, I believe that Ms. Frendel should have reviewed her records.
Okay. And if it was determined that Dr. Ritzie was not the child's therapist at the time of this child custody evaluation, would that have made any difference about whether or not you thought those records were essential?
Well, if Dr. Ritzie was not providing treatment to the child at the time of the custody evaluation, the social study from Ms. Frendel, then I would wonder, why would she have been requesting records from Dr. Ritzie if she wasn't involved?
Well, let me give you a hypothetical. What if Dr. Ritzie had seen the child for some small period of time and then was removed from treatment of the child? Would you still need to see her records prior to completing the evaluation?
Yes, ma'am, I would.
And I'm showing you back on deposition exhibit number 1, we have this little catch-all right here. When the information is received, it may be forwarded to the court and attorneys of record. If the information warrants a change in the conclusions or recommendations, an addendum to this report will be filed. Do you see that?
Yes.
And you see that would be her stated limitation as regarding these items.
I see that as a nice cover CYA kind of sentence, 2 sentences, but in reality, she doesn't talk about what different conclusions will be made from that. So for example, when it says employment wasn't verified for either one of the parents, well, if you turned around and you looked and you found that one parent didn't have a job, or the other parent was lying about what kind of job they were doing, and let's say they're dealing drugs or selling heroin on the street, that's a significant piece of information that would definitely change the recommendations. So when Ms. Frendel has some of those very important pieces of information that she hasn't looked at or received yet, and goes ahead and issues a report, particularly one with a recommendation of sole custody, I don't think those 2 little CYA lines cover what you need to be doing here. That's significant information that's missing that she didn't look at, in my opinion.
But if you review the facts of the case, Dr. Milburn, you would see that the father is self-employed and the mother is unemployed. Do you still think it's essential that you verify the unemployment and self-employment of those 2 parties and how it somehow would affect the best interest of the child?
Yes, ma'am, I do. But it's not just one of those things, it's all of those things.
You're stating the 5 limitations that she stated. Is that a yes?
Yes.
In your opinion, is that this catch-all that she put down here, these CYA sentences, as you called them, are not sufficient to state the various outcomes that could occur had this information been received?
Yes.
And give the court an example of what could be an alternative recommendation had she received the mental health records of Dr. Rochelle Ritzie.
If Dr. Ritzy's mental health records had shown that Lauriston in her notes had first come in talking about, let's say, father's allegations and the report to CPS is accurate, what CPS investigator wrote. Let's say Dr. Ritzy's notes have Lauriston, or Logan, as he's now called, say, I want to be called Lauriston. I don't want to be called Logan. If her notes say, Mom bit me on the back and I didn't think she was playing, it hurt me. If the notes said, my uncle was in the bath with me. If the notes said, I want to go back to Dad's house. If the notes said something about the child saying, I don't want Dad to change anything in my room. I want it to be exactly the same. So when I get back, it's exactly the same, which apparently is in some kind of communication between the father and the child at some point that was in the depositions. The point is, if Dr. Ritzy's notes at the beginning of treatment have that kind of record or information in them, and then you come to Jennifer Frendel's social study, and now the child is maybe not so happy about going back with Dad, not sure he really wants to be there. If Ritzy's notes at the beginning show a positive relationship with the child, but by the time you get to the August 2019 report from Ms. Frendel, and it's not as positive, then you have to ask what's going on between the time he started in treatment with Ms. Ritzy and the current point where the child is with the father. Those are important questions. And if the child had told Ms. Ritzy those, and it's in written notes that he told Ms. Ritzy, for example, that Mom bit him, that supports what the CPS records show, what Dad has said, and the pictures of the bite marks on the back of a child's body. For Ms. Frendel, for example, to say, well, I can't see the face of the child, so I don't know if that's Logan or not, in those pictures that she's provided, and just kind of out of hand in her report dismiss those pictures. Well, if the therapist records from back then say that he talked about that with the therapist and it's in writing, that then confirms not only what Dad has told her, not only the pictures that she saw, but also what the child told the CPS investigator.
But Dr. Milburn, you must understand this is based on the premise that what Mr. Crockett has told you is true, right?
No, the CPS investigation is the CPS investigator's notes. That's not what Mr. Crockett has said.
Mr. Crockett has indicated to you that Ms. Frendel refused to accept the pictures because they didn't show the child's face, right?
Objection form. You may answer, Dr. Milburn.
I don't recall if Mr. Crockett was the one who said that to me, or if Ms. Frendel has that written in the report that she can't see the face of the child, so she doesn't know that that's actually the child. I don't recall, it's been a while since I've looked at that, so I don't recall if the father told me that or if that's actually in Ms. Frendel's report. But what I do know is, answering your question, the notes of Dr. Ritzy are extremely important, in my opinion, to have been looked through in an evaluation like this.
If Ms. Frendel reviews all of Dr. Ritzy's notes and therapy notes prior to her addendum, that would alleviate your concerns regarding that section of the Texas Family Code, correct?
Yes, it would.
And if Dr. Chandler, who's been removed from this court, still refuses to provide his notes, do you think that would somehow still be relevant in this case for treatment the child had 5-6 years ago at this point?
Yes, I do.
And tell the court why.
Dr. Chandler saw both the father and the child. Without looking at the notes or the records, there's no way to know whether those were always joint sections, how many times he saw the father alone, how many times he saw the child alone. But we have a case here where Ms. Frendel turned around and made actual mental health diagnoses and diagnosed the father with a personality disorder and diagnosed the father with another mental illness without looking at the actual records of a mental health treatment provider. Those records, I think, are extremely important and need to be reviewed. And Dr. Frendel needs to be interviewed.
And you indicated that she diagnosed him. You would agree with me there was no psychometric testing in this case, isn't that right?
The only psychometric testing in this case was by Dr. Jeff Siegel in the first custody evaluation that I believe was conducted or finalized in 2013, and by Dr. Davidson here more recently, where he did a very extensive evaluation and he did psychological testing.
Objection non-responsive. As it pertains to the child custody evaluation that you reviewed in 2019, you would agree with me Ms. Frendel did not conduct any psychometric testing.
No, I don't believe Ms. Frendel conducts psychometric testing. I don't think that's within her scope of expertise.
Yeah, I agree with you. And you're indicating to the court that you believe she diagnosed the father with a specific condition. Is that right?
When I read her report, if I recall correctly, it looked like she had diagnosed him with a narcissistic personality disorder.
Do you recall whether or not Ms. Frendel cited in her report to potential signs and behaviors that are consistent with narcissistic personality disorder, or whether it was a true medical diagnosis?
I think she may have cited that he had the characteristics of narcissistic personality disorder. And as a mental health professional, if she had concerns that he had a personality disorder or any other mental illness, I believe the Texas Family Code suggests that she refer him out for testing.
And that's if the court order required that it occur, correct?
Well, I think that's also at the discretion of the mental health professional, because, for example, I've had a couple of cases. The case, in fact, that's going to trial in August in the Dallas court is one where Dallas Family Services did the social study, but they needed to have psychological testing of both parties. And so they referred the parents out to me through the attorneys or through the court. I did the psychological testing and got that testing back to Dallas Family Services. So that's been my experience with how that works.
Okay, and I'm showing you deposition exhibit number 4, the Texas Family Code 107110. Do you see that?
Yes.
And it says a child custody evaluator may conduct testing as part if ordered by the court or determined necessary by the evaluator. Is that correct?
Correct.
And the evaluator is licensed to conduct such testing.
Correct.
Okay. And you would agree with me that there's no requirement set forth in the Texas Family Code to refer somebody for testing if it's not within their purview?
Well, the issue is actually that if the social study expert like Ms. Frendel has a concern that a parent has a mental health illness or mental health diagnosis, like a narcissistic personality disorder, then that concern being in a report and using that as part of her basis for making a recommendation of sole custody to the mother and supervised visitation only with the father, by using a mental health personality characteristics as a basis for her recommendations, I believe she's ethically required to have him evaluated again.
Objection non-responsive. Section 107 of the Texas Family Code does not require that a child custody evaluator conduct psychometric testing or refer it out. Isn't that true?
Yes. That would be an ethical problem with Ms. Frendel, not
Objection
a problem with the Family Code.
Objection non-responsive after yes. You've indicated in your report that you believe Dr. Frendel offered opinions without completing the basic elements of an evaluation under 107. Can you specifically define for the court which sections of the code you believe she failed to complete, or which elements she failed to meet?
Yes.
And if you need to take a break, Ms. Milburn, I know we've been at it for about an hour and a half, so you let me know anytime.
Okay, thank you. I'm okay.
Okay.
I've got my water here.
Okay.
All right. So in the Texas Family Code 107.108, the general provisions, it says that a child custody evaluator should follow evidence-based practice methods and make use of the current best evidence in making assessments and recommendations. So I give you a list of several things, and are you wanting me to go through this?
It was kind of a blanketed statement in your report. And so I was trying to get some understanding about specifically what subsections of 107 do you believe that she failed to meet?
Okay. I apologize if it seemed kind of blanket. So one of the concerns as we go through here is she didn't do balanced interviews with the parties. The Texas Family Code says do balanced interviews with each party. She did not do that. She did an individual interview with the father. She did a joint interview with mother and boyfriend. She did an interview observation with the child and the father. She did a joint observation with the child and the mother with the boyfriend, now stepfather, present. She took information from the mother that she used and she listed in her report, such as a list of characteristics of narcissistic personality disorder, and actually put that in her report. And that is definitely not best evidence. Best evidence that you would follow when you're talking about any mental health diagnosis would be looking at Dr. Chandler's report, who's a mental health professional who worked with the father and the child, looking at Dr. Arazo's information, since he's providing treatment as a psychiatrist to the father, looking at the report and the information. I believe father's in individual therapy with, I believe that therapist's name is McFarland, and talking to that mental health professional and looking at those records of the father's treatment. And she didn't look at any of those records based on the father's treatment, but she looked at records based on only the mother's treatment. She got the mother's mental health information. And then she turned around and she drew conclusions and made statements in a report regarding the father's narcissistic personality disorder characteristics. That's not best evidence. Best evidence would be going directly to the mental health professionals who have worked directly with the father, not using some sheet mother has printed off, or going directly to Dr. Jeff Siegel, who did provide psychological testing of the father back in 2013. And if I may add, a personality disorder is actually a long-standing personality disorder. To receive any diagnosis of that, or to even have characteristics of that being indicated as her role as a mental health professional, Ms. Frendel knows that a personality disorder begins in adolescence and very early adulthood and follows an individual throughout their life. That is one of the reasons why you always look to see where a person went to high school, what their adolescence was like, what their background, because a lot of those personality disorder diagnoses require those behaviors to be present and impacting a person's life prior to the age of 18. That's a failure to use best evidence. Again, she should have gotten the mental health records from Dr. Ritzy. She conducted unbalanced information, getting collateral information on people in this case. She took 3 positive statements from collateral sources for dad. She took 3 for mom and 3 for stepdad. Mom and stepdad are aligned. This is a case, particularly in any kind of family law case, where you've got a mother and father who disagree about what's in the best interest of the children. Essentially, she only took 3 statements, collaterals for the father, and she ended up taking 6 positive for the mother's side. And if you count the stepfather as an additional source in support of the mother, it's actually 7 collaterals positive for the mother's side. That is an unbalanced evaluation between these 2 parties. She accepted materials and reviewed materials that the mother gave her and she denied reviewing and accepting materials that the father brought for her. Then we have the information about the car accident that occurred in, I believe it was 2013. In this car accident, the mother makes allegations now to Ms. Frendel that the father attempted to murder her, that this was an attempted murder situation. That's a relevant piece of information. That is something that the mother is alleging. And to look at that and to place that in her report, but to refuse to review the police reports back at that time, to review the mother's statements back at that time, to review the mother's statements made to Dr. Siegel at that time of the event, and the wording in the report, she's not using best evidence-based methods on looking at this. Instead, she's using more he said, she said, what the mother has said to her as somehow being factual and discounting what the father has said to her, in my opinion, in terms of reading how she wrote that up in her report with all of the biased wording.
Dr. Milburn, you're giving me all of your supporting information for each one of these. I'm asking you just to outline them for me. So right now we're talking about the 2013 accident. We'll come back and hit every one of these. Just give me your outline form.
Well, the outline form would be, she also didn't verify each statement of fact that she's supposed to look at according to the Texas Family Code under section 107.113. She also did not provide the extent to which all the information that she did not look at limits the reliability and validity of her opinion and the conclusions that she drew under section 107.113. Under 107.109, she offered an opinion of conservatorship of the child in this case without all the basic elements of the child custody evaluation being completed, in my opinion. She did not have an individual interview with the mother. She did not have bounce interviews between the parties. I don't believe, if I recall correctly, she looked at relevant school records. She did not do a criminal history check related to each individual who's living in the home of the child. There's no criminal history check on the stepfather. And the criminal history that he reported didn't make any sense in her report. If I recall correctly, she said that the stepfather had an arrest and a conviction for something as a minor, transporting illegal substances when he was 20. She's supposed to conduct a criminal background check on that, and 20 is not a minor. So I couldn't figure out from her report what she'd actually done with that, but you're required to have a criminal background check on everyone living underneath the roof where the child is. And she's also supposed to obtain information from any collateral source that may have relevant information. There are several people that have relevant information, including Dr. Chandler, Dr. Arazo, that she did not receive any information from, according to her written report. She did not request psychometric testing, but gave statements in her report regarding the father having a narcissistic personality disorder, which is a mental health diagnosis. Family Code 107.1101, effect of potentially undiagnosed serious mental illness, sections A, B, and C, states that Mrs. Frendel should have made a referral for the mental evaluation of the father rather than making a diagnosis based on only one individual interview and information from other sources which may or may not have been accurate. She failed to identify problems with the mother's credibility, where the mother showed a change of information and changes to her story from 2013 to 2019. And there was a concern for me in the CPS records that she should have reviewed. She's required by the Texas Family Code to review all the CPS records that are available. And in the ones I read and reviewed, it showed the mother's statements regarding the issue that occurred in the bathroom with the uncle to be different than the uncle's statements to the CPS investigator in 2017, which is a part of the reason why this case ended up being filed to begin with. That and the bites on the back. And she concluded that the father was making false allegations regarding the child, even though the CPS investigator has in the written records that the mother admitted to biting the child on the back. I believe she failed to use the best standards of research on which to base the conclusions of the recommendations that she's made. She also failed to give each parent the opportunity to respond to the other parent's allegations properly. When I do an evaluation and I get a list of allegations from a parent against the other parent or the party, that other party has a right to come in and to talk to me or to do an interview by phone, Zoom, whatever, or in written form to answer all the allegations that the other party is making. She did not do that in the report that I read. Does that cover it?
Question non-responsive. So I am, sorry, Dr. Milburn, I needed a list, and we have a lot of information now that we're going to have to double back on. So, excuse me, we have talked extensively about your opinions regarding what you deem to be an unbalanced interview of the child, unbalanced interview of the parties in this case, correct?
Correct.
And we've talked about how you believe that she failed to obtain the mental health records of Dr. Chandler and Dr. Ritzy and how that's significant to you, correct?
Yes.
Okay.
And Dr. Arazo, if he in fact was present during that time providing treatment for the father, which I believe he was.
Are you aware of whether or not the records were actually received by Ms. Frendel regarding Dr. Arazo?
I am not. They may have been.
Okay. And, and let's just clear that up. I am showing you child custody evaluation deposition exhibit 1. It indicates that the mental health information from Dr. Sawyer and Dr. Arazo for the mother were both received by Ms. Frendel. Does that resolve that concern?
I believe Dr. Arazo was this father's treatment
And
provider.
so Dr. Arazo also, Mr. Crockett presented a letter from Dr. Arazo regarding his agoraphobia as well during the course of the evaluation. Do you see that here?
I do see that.
Okay. And additionally, with the school information report cards from the elementary school for the child Logan, do you see that?
Yes.
Okay. And so
Okay.
excuse me, you've indicated that you believe that Ms. Frendel had an obligation to further interview school providers other than just reviewing the records. Is that your testimony?
Yes.
Which providers do you believe she should have interviewed?
I think she should have talked to his primary school teacher. One of the big questions in this case had to deal with the name that the child was using. So the child was in school, if I understand correctly, and was going by the name Lauriston. His birth certificate says Lauriston. The teachers were calling him Lauriston. And according to Ms. Frendel's written report, I believe the child told her he preferred to be called Lauriston. The mother, I believe, according to the report, told her the child has been called Logan, that the father agreed that he could be called Logan because she wasn't really happy about the idea of them having the same name on the birth certificate, and that she went ahead and let it happen, but only because he agreed to call the child Logan. And then you had a household, if I understood correctly, when Ms. Frendel did her evaluation, where in one house he's called Lauriston and in another house he's called Logan. I think it would have been a good idea to talk to the school teacher to see if in fact that what the child had said in school, and if in fact the child was being called Logan or being called Lauriston. And then there were allegations made to Ms. Frendel about the father's behavior in the school that she put in her report. that the father had said certain things to the child in the lunchroom when he had gone to lunch. And those were things that the mother had reported to her. And she put them in her report, which means she had to have given them some relevance or some weight that she reported that. And she concluded that the father was doing parental alienation based on how the father was being reportedly around the child and what he was saying and doing. I think she should have, for best evidence, spoken to a collateral source at the actual school, which would have been to one of his teachers or his principal or his counselor, somebody who could have verified what mother said or discounted what mother said.
Objection, non-responsive after the teacher. And you indicated that you were concerned about the fact that letters of recommendation were received 3 by the stepfather, 3 by the mother, and 3 by the father. Is that correct?
Yes.
And you perceive that to be an unbalanced review of information in favor of the mother. Is that correct?
Yes.
And can you tell the court how you believe having an unbalanced gathering of information could somehow upset or change the recommendation regarding the best interest of the child?
Sure. As a child custody evaluator, if I get twice the number of things for one parent that says, oh, they're really great and wonderful, than I get for the other parent, then I automatically have tipped the scale of the information that I am putting into my brain and under my evaluation process. I've automatically tipped the scale in favor of the parent that has more positive information coming in. It's a bias.
And just to be clear, that's the same bias you're exercising today, having only spoken to Mr. Crockett.
Objection form.
And you said yes. Is that right, Dr. Milburn?
Yes.
Okay.
It's not the same bias, but it is a bias.
Okay, I understand. And basically what you're telling this court is because they got more information from one party and then the other, that you feel that that could have affected the outcome of the recommendations.
Yes, and she elicited more information in favor of the mother than the father. So there's also a difference between parents who just bring in stuff. Sometimes I have parents who bring me in a whole host of stuff. So I may have 10 letters of reference on one side and not any on the other side. But I'm not seeking out an unbalanced amount of information. So if I actually am seeking it out as a child custody evaluator, and I am seeking out and receiving twice as many positives for one parent over the other parent, I am biasing the information coming into my brain and my evaluation process in favor of the person I'm getting more information from.
Objection, non-responsive after yes. And we have talked also about your opinions regarding Ms. Frendel referencing the criteria for narcissistic personality disorder. Is that right?
Yes.
Okay. And you've indicated that you believe the wording used indicates a diagnosis. Is that correct?
When I read her report, it appeared to me she was diagnosing him.
Okay. And one of the other things you mentioned in your list was failure to obtain information regarding the 2013 car accident. Is that right?
That's correct.
Isn't it true that Ms. Frendel indicated she's not making any recommendations or considerations of that event?
Well, while she may be saying that at one point in her report, the totality of reading her report indicates that that may be otherwise.
Objection, non-responsive. Isn't it true, Dr. Milburn, that Ms. Frendel made it very clear in her report that she is not considering that information from either side?
Objection form.
To the best of my recollection, I believe she had a paragraph toward the end of her report where she made that statement.
Okay. And are you aware that the court has specifically excluded that topic from the trial in this case?
I'm not aware of what the court has done
Okay.
related to that topic.
Okay. And if the court has precluded the parties from discussing that, wouldn't you think it's appropriate for the court, the evaluator, to also not reference that in her report?
Well, the problem is she did reference it in her report and she called it an incident rather than an accident.
Objection, non-responsive. If the court specifically has excluded that topic from being referenced in trial, in this case, wouldn't you agree with me that the evaluator should not consider that event, incident, accident, or otherwise, when making a recommendation in this case?
Well, I absolutely believe if the court has ordered that Ms. Frendel should not be using that as a basis for anything that she recommends or puts in her report. However, I do believe she has done that in her first social study, which is what I reviewed.
Objection, non-responsive. Any statement prior to, however. You indicated that there were concerns regarding the CPS records in this case. Is that correct?
Yes.
Did you review the CPS records?
Yes.
And you are aware that father has made 7 CPS referrals in this case that were all ruled out, right?
I don't recall the number.
Would it be concerning for you as an expert conducting a child custody evaluation if one parent had repeatedly contacted CPS and those allegations were ruled out?
Objection form.
It is always something that I look at when I'm doing a custody evaluation. Who's contacted CPS, how many CPS reports have been made, what the conclusion from the CPS investigator has been made, has occurred. So I do look at that.
And when you look at those things, how do you weight that? Does that go to credibility? Is that a best interest determination? How do you use that information?
I want to say all of the above. I actually, every case is unique. Every case is individual. So I look at the allegations. I look to see whether or not there's some credibility to them. Is there something that is reasonable for them to have been done, even if they have been, maybe determined by the investigator to not be relevant. I look at the number that has been done over a period of time, and I look if it's being done during the process of a divorce high conflict dispute regarding the child, or if it's before, or, that kind of when it's done has significance as well.
And you're not suggesting that Dr. Frendel also, excuse me, that Ms. Frendel also did not consider those same things, correct?
No, I think she considered those.
Okay. And you indicated that you believe Ms. Frendel, and I wrote this down quickly, and overlooked negative information about the mother. Did I say that right?
That she overlooked possible negative information about the mother.
Okay, and can you tell me, was the possible information that the negative information that she should have considered given to you by Mr. Crockett?
I don't know if it's given to me by Mr. Crockett or by Ms. McKnight or who provided it to me. There was information that was overlooked, in my opinion.
Okay, but your opinion is that somebody had given information to Ms. Frendel and it's not referenced in the report. Is that right?
I do understand that the father said he tried to give her information that she would not take.
And again, that's based on the premise that the father is telling you the truth when you're making that statement to the court, right?
Yes, and the father then provided me with that information, so I had a chance to look at it, and it was not listed in Ms. Frendel's report, so it didn't appear that she looked at it.
But again, if you haven't reviewed everything that Ms. Frendel received and you're not certain of what all she had in her possession, it's fair to say you don't know if this information was ever given to Ms. Frendel. Isn't that true?
Objection form.
Well, I believe Ms. Frendel provided a full list of everything she did look at in the report. And so if she didn't put it on the list, then I would take that as an indication that she did not review it.
And can you tell the court what negative information Mr. Crockett purports to have given to Ms. Frendel that was not regarded, or considered?
That's a difficult thing to do off the top of my head. I can give maybe a couple of examples.
Okay.
I believe that, again, the police report regarding the incident in 2013 was not in the list that Ms. Frendel reviewed. I believe that the best answer would be for me to sit and go through the list that she reviewed and the list of things that I reviewed to see what doesn't match up. That's the best way to do that.
Okay.
I want to be as accurate as possible when I'm answering questions.
I appreciate that. Are you even aware whether a police report exists for the 2013 accident?
Yes, there definitely is a police report.
And who told you there was a police report?
I believe the father gave me the police report.
So you've personally reviewed the police report for the 2013 accident?
Again, I had to look through my records, but I think I did. The police were called to the scene. There were police, ambulances, emergency people on site. So I know there's a police report. She was transported to the hospital. I believe she was pretty seriously injured. I think she had to have surgery. I think she may have had a crushed pelvis. It was a pretty significant event. And I believe, I'd have to look, my records are so thick, but I believe I saw that police report.
Okay, and you referenced a police report regarding somebody bathing with the child in your report. Do you remember that? Yes,
I think I did see that police report. No, that was a CPS report. I don't recall a police report. I think it was a CPS investigator that the child said that the uncle, what I saw in the report that I'm recalling is the difference between what the mother said and what the uncle said. I think the uncle lives in another state, it's either Colorado or California. Mom said she was in the kitchen, door was open to the bathroom, and he was in the bathroom. He wasn't in the bathroom. Uncle said he was in the bathroom helping bathe the child to get ready, and the door was closed. Now, again, neither of those indicate that there's any kind of inappropriate sexual event that happened in that bathroom. Father's the one who claims that the child said uncle was actually in the bath with him. CPS investigator interviewed, got two different stories, but really sounds like kind of concluded, didn't hear anything that there was some kind of sexual gratification going on. And personally, I found myself wondering, okay, the kid was about 4 or 5. And so again, this is where ethnicity and culture comes in. That might be kind of an okay thing in mom and uncle's culture. That's kind of at that gray area, I think, in terms of age, whether or not an adult gets in a bath with a child, or if an adult's in a bath and you're going to bathe the kid real quick and get him out. Some people culturally will do that. Some people, I mean,
objection.
I'm sorry, I digress.
And so let me ask you this question. When you're conducting a child custody evaluation and there are numerous CPS reports and all of those allegations have been ruled out, do you take it upon yourself as the evaluator to go reevaluate the circumstances of those investigations to determine if the outcome was proper?
I do not reevaluate the circumstances to determine if the outcome is proper, but what I do, and I believe I'm required to do when I'm doing a custody evaluation, is to see whether or not those allegations are being done maliciously with no support for them, or if they're being done with a perception on the parent's part who's making the allegation that these have actually occurred. Because that's a difference between whether or not we're looking at somebody who's doing straight parental alienation versus somebody who believes the child may be injured or maybe having trouble, and they're basically making a call for help or they're making a report. And so I'm not reinvestigating what CPS has done, but I am looking at the motivation behind what the parents are doing. So if I get a parent who's making, let's say, false allegations of sexual molestation, and there's no support for those allegations being made, they're basically fabricated. That looks very much often like parental alienation. And that's a real problem leaving a child in that home when you have false allegations being made. But if the parent's making allegations where there's some outside corroboration, there's information there that supports what they're telling CPS, then, and if the child is making the statements as well, then what happens is that doesn't look like parental alienation. So even if the CPS investigator dismisses a complaint, if there's still credibility in terms of making the complaint, then I don't have a parent who's just attacking the other parent maliciously. I may have one that's confused and thinks something's abusive when it's not, according to CPS, but it is my role as a child custody evaluator to look into all of that. It's part of why we look at CPS records to begin with, and the determination between whether or not something is true abuse, parental alienation, estrangement. We have to look at those to determine which one of those three things is going on when you've got a problem between a parent-child relationship.
You would agree with me the quantity of CPS complaints is highly relevant when doing that evaluation?
It can be.
Especially if the high quantity has been ruled out and statements have been made by CPS where they have concerns about one parent using them for alienating purposes, correct?
Objection form.
Go ahead, Dr. Milburn.
It can be. And it depends on whether or not the 7 complaints, for example, are all different complaints or are all 1 or 2 complaints that have resulted in 7 different reports, because that sometimes happens too.
Understood.
Hey, Chris, we had a good point. Take a quick break.
Sure, we don't, and can we go off the record for a second, Charles?
Sure.